Hey, it's Rob Ryder on Veterans Day, 11/11/22. Gotta like those numbers. Today we're going to talk about Justice Gorsuch exposes administrative state's Achilles heel. That's my perception of it, and this is based on earlier this week. Justice Gorsuch dissented in a case where a veteran was trying to get a writ of certiorari, and the Supreme Court disallowed it. And Gorsuch dissented, and he gave this 16-page explanation of his dissent. And, it's quite telling. But, so most of this video is going to be me reading what he said. And I guess what I'm going to say before that then is what I get out of it is he's telling us that, back since the 40s, we've gone under the administrative state. Basically, the New Deal started the administrative state. And then in the 40s, it got a big kick and got, bigger and bigger and bigger. And what the administrative state did was basically, because it was a different form, right? It doesn't follow the law, it follows its regulations. So, it doesn't necessarily care what Marbury versus Madison said way back in the day, that precedence, right? It created its own. And we've been working under these new precedences of the administrative state. But, they're not the law. So they don't follow the law. They follow their own internal procedures. But what Gorsuch is saying is, the courts don't have to let them do that. And I think what the problem is that we are not asking the court to apply the law to particular adjudicative facts. And if we did that, then that could open the door for the court to apply the law. But because we're under this new presumption, that the administrative state gets to determine, basically the executive branch, gets to determine what the law says, instead of the judge determining what the law says, we have the situation we're in today. Now, caveat, as far as I'm concerned, none of these people are who they say they are. I mean, Justice Gorsuch, I do not believe, has taken an oath to satisfy the 6th article of the Constitution. Neither is the governor, neither is any state judge, neither is the representatives or the senators or, any state officer or any United States officer. Anybody that you could say, well, the 6th article applies to you, they didn't take the oath to satisfy it. Nevertheless, these people are still the courts. It's where they take us to. So, if he's going to give us a way to work in this new court system, I think it should be explored. Which is, comes down to as simple as something like this. Then I'm not saying this is what I would send. I would just play us with some stuff because, that's what I do. So, motion court, take judicial notice of adjudicative facts, apply the law, issue an order. Right? That's what I want the court to do. The court can take judicial notice of adjudicative facts. That's under the rules of evidence. But the other part is to have them apply the law to those facts. And then based on that, issue an order. So more on that later. Right? This is all something we might talk about later. Just depends on how long this video gets. So let's get started. I am Staff Sergeant Robert Allen Rutluski, U.S. Army veteran. On Veterans Day, also known as Rob Ryder, with 2 B's. My email address is robryder. Oh, that really isn't my email address. What am I saying? That'd be the wrong one. Is Court of Record, COURTOFRECORD, at AOL.com. That's my email address. And my YouTube channel is Rob Ryder with 3 B's, ROBBBRYDER. And okay, so give me just a second here and I'll load a few things up. We'll get started. Okay, I just want to show real quick. This is the Supreme Court courtroom, and it's got these 2 big-ass gold fringe flags in it. Well, the gold fringe flag is regulated by Army Regulation AR 840-10. And it says in Chapter 2, Subsection 3, where the gold fringe flag can be displayed. And one of the places it can be displayed is a military courtroom. Every other place it can be displayed is some office that has something to do with the military. So it's a military flag. So the Supreme Court may be a military court of some kind, which, I say the Constitution has been suspended since 1863, and that we're under some form of military rule, and there's the evidence, right? So I'm just saying that these are not the constitutional courts of the Constitution, but it doesn't mean it can't, make everybody that's subject to it follow the Constitution. So let's see what one of the people that sits here, in front of the gold fringe flag had to say. In this particular case, it's Justice Gorsuch, right? Decided November 7th, 2022. Might just be a few days ago. And let's read on. So, petition for writ of certiorari is denied. And Gorsuch is dissenting. So, Thomas Buffington served the nation well, but the Department of Veterans Affairs failed him. Well, how many veterans can say that? Anyone who's gone to the VA can probably say that. Relying on its own internal regulations, the agency denied Mr. Buffington's disability benefits that Congress promised him by statute. When I read that statement, it blew me away. I had to get out my highlighter. And unfortunately, from there, I've highlighted almost the whole thing. But, right? So relying on its own internal regulations, whatever those are, those could be the Code of Federal Regulations, CFRs. But they have other stuff they've written. So which ones are we talking about? Right? The agency, the VA, denied the veteran his disability benefits that Congress promised him by statute, which is the law. So the VA is not following the law, it's following its own internal regulations. That's the administrative state. So nor is Mr. Buffington's case an isolated one. The VA's misguided rules harm a wide swath of disabled veterans. Making matters worse, the lower court, in this case, turned aside Mr. Buffington's petition, asking them to set aside the agency's regulations and apply Congress's statutory instructions as written. Right? So the lower courts turned aside Mr. Buffington's petition, asking them to set aside the agency's regulations and apply Congress's statutory instructions as written. Now, why do they call them statutory instructions? Why do they call it the law, right? The law. Let's do the law. So instead, the court invoked Chevron deference, bypassed any independent review of relevant statutes, and allowed the agency to continue to employ its rules to the detriment of veterans. Respectfully, those who've served the nation's armed forces deserve better from our agencies and courts alike. So we can stop right there. I agree with you 100%, Justice Gorsuch, but I expect you to do more than just dissent about it, and then sit back in your chair and do nothing else. Go file a criminal complaint. This is criminal. But they probably won't do that. So what was this? So instead, the court invoked Chevron deference. Well, we'll find out what that's about in a minute. So during his 8 years in the 90s, Mr. Buffington suffered a facial scar, a back injury, and tendonitis. After his discharge in 2000, he joined the Air National Guard. At about the same time, recognition of the injuries he suffered while on duty, the VA assessed Mr. Buffington's 10% disabled and awarded him benefits. The VA did this pursuant to a congressional promise that the United States will pay compensation for disability resulting from personal injury suffered or disease contracted in the line of duty. And that would be under 38 United States Code, right? 1131. So in this case, they're talking about the United States Code. Soon we'll see they're going to talk about the Code of Federal Regulations, which is, a different book. Mr. Buffington's time away from active duty proved short. In 2003, federal government called him back in. As a result, he served on active duty, blah, blah, blah. And then it said, in doing so, everyone agrees that the agency acted properly under statute that empowers it to withhold benefits for any period in which a service member receives active service pay. Right? So apparently there's a law that says they can do that. Right? So it'd be 38 USC 5304. But it's still a law. We're not in the Code of Federal Regulations yet. So in one case, as we can see right now, the VA followed the law and did what it said. Okay, you're going back in active duty. We're going to withhold your benefits. Why? Well, because the law says to do so. Can't argue with it. The trouble began after Buffington left active duty and the VA failed to resume his disability benefits. When Mr. Buffington realized what had happened and inquired about the problem in January 2009, the agency acknowledged its legal duty to pay and agreed to resume future benefits. But the agency also informed Buffington that it refused to pay benefits retroactively beyond February 2008. All of which meant that Buffington missed out on about 3 years of disability payments from 2005 to 2008. Well, why did the VA refuse to pay the benefits? According to current agency rules, right now we're coming into the CFRs, a veteran must ask for his disability payments to resume after a second or subsequent stint on active duty. If a veteran fails to ask for his benefits again, the agency will not provide them, nor will the agency pay benefits retroactively beyond 1 year prior to the date of the veteran's reinstatement request. Right? 38 Code of Federal Regulations 3.654. So, right, the VA wrote its own internal rules and said, well, this is how we're going to handle this situation. And so, they gave him 1 year retroactive, but screwed him out of 3 years. But had he not gone and asked about it, he would have never gotten it again. So in the Court of Appeals for Veterans Claims, Buffington challenged the court's rules as inconsistent with Congress's statutory commands. After all, the law says that the VA may suspend disability payments only for periods when a veteran receives active service pay. All right, 38 United States Code. Right, so again, we're back to the law. So after all, the law says that the VA may suspend disability payments only for periods when the veteran receives active service pay. So when he came back, he should have started getting paid when he came back off active duty, he should have got his VA reinstated. So the court, however, found it unnecessary to decide for itself whether Mr. Buffington's reading of the law was the best one. Instead, the court concluded that Congress did not speak to the precise question at issue. Whether the Secretary may predicate the effective date for recommencement of benefits on the date of the veteran's claim. Right? So because they didn't specifically say they're not going to make a decision. We're going to pass on it. Given that asserted ambiguity, the court invoked Chevron, USA Incorporated versus National Resource, and deferred to the agency's rules. More of the same awaited Buffington in his appeal from the Federal Circuit. Still, not everyone saw the case the same way. In the Federal Circuit, Judge O'Malley dissented, arguing that Buffington should have prevailed based on bedrock principles of statutory interpretation. Yet he didn't do anything about it except dissent. That ain't quite enough there, Judge O'Malley. The law Congress adopted promised Buffington benefits from the moment he left active duty in 2005. The VA had no business requiring him to petition for them a second time, and the agency had no business withholding 3 years' worth of overdue payments. I couldn't agree more. Judge, do something. Right? File a criminal complaint. In the Court of Appeals for Veterans Claims, Judge Greenberg contended that the majority's invocation of Chevron was nothing more than rubber stamping of the Congress's attempt to misuse its authority granted by Congress. Yet the court let him do it anyway, so apparently they're an accessory to the misuse of authority granted by Congress. Courts, he said, must stop this business of making up excuses for judges to abdicate their job of interpreting the fucking law. Internal quotation marks omitted. Hey, what does that mean exactly? Can somebody tell me? Internal quotation marks omitted. I know there's a difference between double quotes and single quotes. And they're saying the internal quotation, they didn't say double quotation, were omitted. So what does that mean? So anyways, now this is Gorsuch talk, and I very much doubt that the courts below did right by Mr. Buffington. You're correct. How come you're not helping him? As Judge O'Malley and Greenberg highlighted, Congress has instructed the VA to make disability payments to injured veterans like Buffington. In 5304, Congress suspended the obligation only for periods when the veteran receives active service pay. Nothing in the statute requires a veteran to ask the agency to resume benefits it already legally obligated to pay. Nor does anything in the statutes allow the VA to withhold overdue benefits. It seems that even the VA once acknowledged all this before adopting its current rules. The agency previous rule imposed no time barrier and indicated that payments may be resumed the day following release from active duty if otherwise in order. Right? So the VA changed its own rules to not pay veterans. Even more troubling than the answer the lower courts reached in this case, however, is how they got there. Neither the Court of Appeals for Veterans Claims nor the Federal Circuit offered a definitive and independent interpretation of the law Congress wrote. Instead, both courts simply deferred to the agency's current regulations as reasonable. One and said this court's decision in Chevron requires them to do so. Right? And said this court's decision in Chevron, because the Supreme Court made this particular rule in Chevron, requires these lower courts to do whatever the administrative state tells them to do, because they get to determine what the law is. Right? Right? We're going to defer to the administrative state and let them determine what the law says. That kind of judicial abdication disserves both the veterans and the law. Thank you very much. You just said they violated the law. There, Justice Gorsuch, file a criminal complaint. From the beginning of the Republic, the American people have rightly expected our courts to resolve disputes about their rights and duties under law without fear or favor to any party, the executive branch included. The origins of judicial deference to executive interpretation, that's where you can read about this stuff. So, in this country, it was well established early on that courts are not bound by administrative constructions of the law, and those constructions may be taken into account only to the extent that they are supported by valid reasons. Right? So there's a case to quote. To be sure, the administrative state spread its wings in the 1940s. This court toyed with the possibility of departing from this long-standing tradition of independent, non-deferential judicial determinations of questions of law. Well, that was all settled in Marbury versus Madison. It's called judicial review, at least when it came to so-called mixed questions of law and fact. Okay, so now we don't have just questions of law, and then we have this other subcategory, questions of law and fact, and we're going to handle those differently. We'll just say it was a matter of law and fact, and so we didn't have to take any action. But it didn't take long for a chorus of prominent voices to denounce the prospect. For example, for the ABA said that the protested against the recent trend of giving interpretation of statutes to the executive or to the administrative officials, a trend that Pound worried would lead to administrative absolutism. And we got there. Or warning this court against abdicating its function as a court of review and completely reversing the normal usage and methods of construing a statute. Right? That'd be the common law, how all this had been done. The precedence that has hundreds of years old. They just quit doing it and they went to something new. In 1946, Congress put any question in this area to rest when it adopted the Administrative Procedures Act. Despite sharp division among partisan lines, Congress passed the APA unanimously. Does that mean everybody said yes? All 450-some congressmen and 100 senators, whatever it is, they all said yes? I don't know. Thanks to this hard-fought compromise, right? The Administrative Procedures Act emerged from the New Deal politics. On the one hand, the APA allowed agencies to issue binding regulations and required courts to defer to agencies' fact findings. On the other hand, the APA provided that courts, so this is out of the Administrative Procedures Act now, the court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of those terms of agency actions. Right? So the Administrative Procedures Act says the court shall decide all relevant questions of law, interpret constitutional and statutory provisions, right? And determine the meaning. So they should be able to take the Constitution or statutory division and say, does that apply to this person here? Court, yes or no? So in my case, what I'm talking about is, okay, there's the prosecuting attorney prosecuting you. Can you ask the court, well, Judge, is this man bound by the 6th article of the Constitution? Is he one of the classes of people they're talking about? And did he execute the oath that's required to satisfy the 6th article of the Constitution? Yes or no? And if he didn't, then you have to, if he is bound and he didn't take the oath, then this is a, malicious prosecution. And he's in criminal contempt of court. And I need you to order an acquittal. Blah, 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 blah. To try to use the fact that they have to decide all relevant questions of law, interpret constitutional statutory provisions. So have them do so. Ask them to make a decision. Instructing courts to hold unlawful and set aside agency actions is not in accordance with the law. Or actions not in accordance with the law. So 706 of the Administrative Procedures Act, so it must be 5 U.S.C. 706, instructing courts to hold unlawful and set aside agency actions not in accordance with the law. So if the agency didn't execute the proper oath of office to satisfy the Constitution, then it's not in accordance with law. More on that later. In short, the APA appeared unequivocally to instruct courts to apply independent judgment on all questions of law. As a leading contemporary scholar on administrative law put it, the statutes impose clear mandate for courts to decide questions of law for themselves in the exercise of their own independent judgment. More explicit words to impose mandate could hardly be found. After the APA's passage, courts more or less followed this mandate faithfully for decades. Some justice himself, an ardent New Dealer, before joining the bench, explained courts would respectfully consider executive branch interpretations of law, but the weight courts afforded them depended upon their thoroughness, their consistency with earlier and later pronouncements, and all those factors which give them power to persuade. The interpretation of the meaning of statutes as applied to justiciable controversies is exclusively a judicial function. So the administrative state can't do that. They don't get to interpret the statute. The judge does. In fact, many prominent judicial opinions in the decades following the adoption of the APA never even mentioned executive branch interpretation of disputed statutory terms. Right? And something failed the Chevron experiment now. Okay. So anyways, as some tell it, Chevron effected a revolution in 1984. As the story goes, the decision overthrew all that came before. Right? We're going to get rid of all the frickin' case law from before this and enshrine new rule requiring courts to defer to executive branch interpretations of the law. We're going to get rid of what we were doing, which was to have the courts interpret the law, and now they're not going to, and we're going to have somebody else do it. The executive branch gets to interpret it. No longer did executive branch officials have to be right about the law's meaning to prevail in court. Can I read that again? No longer did executive officials have to be right about the law's meaning to prevail in court. All they had to do was point out to some relevant statutory ambiguity or silence and avoid being egregiously wrong. But the lower courts in this case adopted just this line of reasoning when they turned aside Buffington's appeal. So let's see. So what did they do? The lower courts in this case adopted just such a line of reasoning when they turned aside Buffington's appeal. Right? So what was it? Well, that no longer did executive officials have to be right about the law's meaning. Doesn't matter what the law says to prevail in court. All they have to do is point to some relevant statutory ambiguity or silence and avoid being egregiously wrong. So unless every jot and tittle is put in the law, they're saying they don't have to follow the law. They're going to follow their statutes, or they're going to follow their Code of Federal Regulations, or some other thing. So, doubtless Chevron contained language that later courts would read as representing significant departure from prior law. Most notably, Chevron included a passage musing that if a statute is silent or ambiguous with respect to a specific issue, the question for the court is whether the agency's answer is based on permissible construction of the statute. But Chevron also proceeded to restate the traditional rule. If a court employing traditional tools of statutory construction ascertains that Congress had an intention on the precise question at issue, that the intention is the law and must be given effect. And so this, again, I think we just have to ask our questions differently to the court. Right? To ask the court to employ traditional tools of statutory construction and ascertain that Congress had an intention on the precise question at issue. The intention is the law and must be given effect. Telling two, Chevron did not express disagreement with precedents reciting the traditional rule that judges must exercise independent judgment about the law's meaning. I mean, how can we even be arguing about this? I thought that's what they did, but apparently they stopped doing it in the 1940s. Right? So they're under this new precedence. We got to bring them back to the original. Because the original is first in time. This is, newfangled. There are precedences that go back for hundreds of years. It's called the common law. Nor did the decision argue that the APA either tolerates or commands deference to executive branch views of the law. To the contrary, Chevron professed merely to apply well-settled principles. Many of these cases Chevron cited to support his judgment stood only for the traditional proposition that courts afforded respectful consideration, no deference to executive interpretations of the law. The court's not bound by an administrative construction, and if that construction is not uniform and consistent, it will be taken into account only to the extent that it's supported by a valid reason. All executive interpretation that had always heretofore obtained was entitled to the most respectful consideration. These decisions, sole citation, legal scholarship, blah, blah, blah. Okay. So I want to stop just here for a second and go show you something because, I'm going to show you an example of the executive interpreting the law. It's amazing all this stuff happened the same week. So I got an email earlier this week. Actually, it was the day I was first reading this thing from Gorge, right, from James from Boulder, Colorado. Longtime listener, your great work. I've been compiling 2 damage claims against judges locally for multiple federal and state constitutional law violations and have met with some resistance in terms of claiming the district judge avoided his federal oath of office. State attorneys, the executive branch claim that because the verbiage contained in 4 U.S.C. 101 is present in the judge's state oath, that is therefore valid. I countered that and stated that the two must be taken separately in succession. The opposition then said to wit does not mean verbatim. It's simply namely. I did confirm the definition of this to be this, however. My counter is that the state constitution did not provide for combined oath. I've had success using Article 6 against these corrupt public officials when they have taken state oath with religious tests, of course. As we know, Article 6 affirms no religious test. So therefore, when it is present in the state oath, it cannot be used for combined oath. So when the state oath does not contain a religious test, it does contain the wordage from 4 U.S.C. 101, and also contains of the state. How can we people counter with an unrebuttable statement of fact? One more issue regarding the pseudonym of the state oath. So I'm very much up to speed in your talks with Gretchen has a case. I agree 100%. And that's where I said that, Gretchen Whitmer, on the oath of office she filed that was supposed to be for the state oath, she didn't use her full legal name. Well, if you don't use your full legal name, then you're hiding your identity. It's not just your name, it's your identification. So here's an example. The Colorado Attorney General, Philip Jacob Weiser, is admitted to the Colorado Bar to practice as Philip Jacob Weiser. His state oath states, I, Phil Weiser, right, do solemnly, blah, 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 though he signed it as Philip J. Weiser. Right? So his full legal name is Philip Jacob Weiser, but in his oath it says, I, Phil Weiser, which is a nickname, so that's not his full legal name. Right? Your full legal name, according to the Real ID Act, is your first names, last name, first names, middle name, last names, no initials, no nicknames, and it can be your surname. So, first name, middle names, last names, surname, no nicknames, no initials. So, Phil Weiser's a nickname, and J is an initial. Can't use it. So he's attacking the validity of the oath. But anyways, I'll go back to the fact, well, the one who's saying this is all okay is the Attorney General. Right? So an agency is making the decision instead of a court about if the judge has to take that oath or not. So just to get to look at the oath real quick, this is what it looks like. Attorney General, oath of office, right? I, Phil Weiser, right? Not his full legal name, and he didn't sign it in his full legal name. And this has a, I do swear by the ever-living God. Well, that's a religious test. Well, if you put the word God in there, I think it makes a religious test. I mean, normally they put at the end, so help me God. That's definitely a religious test, which would make it unconstitutional. But this is unconstitutional, or doesn't satisfy the 6th article because, it doesn't have exactly, like it says in 4 U.S.C. 101, which came out of 1 Stat 23, which is the first law ratified after or first law passed after ratification of the Constitution. Later codified, and it says, this is Title 4 for the states, right? Every member of the state legislature, every executive and judicial officer of the state, well, you would say, well, that's the Attorney General of the state then, shall, before he proceeds to execute the duties of his office, take an oath in the following form. To wit, I, A.B., do solemnly swear that I will support the Constitution of the United States. And the key word here is form. This is the form you need to take it in, not something else, just like this. And A.B. has to be your identification. Right now, that's what I say the law says. And obviously, the Attorney General thinks it says something else. Well, then I want the judge to determine what this law says. What does that say, Judge? What does that mean, compared to this guy's oath? Is this oath that he has satisfy the 6th article of the Constitution? That's the question I want the judge to answer. All right? So here's the oath. Does this oath satisfy 4 U.S.C. 101, 1 Stat 23, and the Constitution, 6th article of the Constitution of the United States? That's what we're trying to get to. And, because the court's not bound by an administrative construction. It doesn't matter what the Attorney General said. We can say what we want to say to the judge and then ask him to take, judicial notice. Okay, in Chevron amounted to a revolution, it seems. Almost everyone missed it. The decision issued by large bare quorum of the court sparked not a single word in concurrence or dissent. Justice Stevens later characterized this in a simple restatement. So I think what Gorsuch is saying here is they made a lot out of nothing. That this case didn't say any of the shit that they're making us believe that it says, or using as the reason for deferring to the administrative state, right? It doesn't say this. It still says that the court has to decide matters of law. And all of the, precedence is in this dissent. So I would think you could be, if you somehow get a certified copy of this dissent and file in your court case and say you're based on this, you want them to, determine the law, that this would have all the stuff in there that the judge would need for him to say, well, yeah, I guess I can. It says it right here. The Supreme Court said I get to decide the law after all. Chevron did not make it so that the Supreme Court said, because this is what they're saying, that, well, the Supreme Court said, that in Chevron that the administrative state gets to determine the rules. They didn't say that. So in truth, it took years for Chevron to morph into something truly revolutionary. 3 years after Chevron, Justice Scalia wrote a concurrence that seized on the passing musings about deference and argued for a new rule requiring courts to defer to reasonable executive branch interpretations of the law whenever a statute is silent or ambiguous. Well, I wonder what rule that is. Right, is that in the Federal Rules of Civil Procedure? 2 years later, Scalia continuing his campaign in an academic article. So Scalia said, hey, this idea of deferring is okay. It takes the burden off the state, right? But reasonable interpretations. So we need to say that their interpretation is unreasonable. It's unreasonable for the Attorney General to say that his oath of office satisfies the 6th article of the Constitution. Because this is what the Constitution says, and this is what the law says. Judge, what do you say? Something like that. Over time, however, experience has exposed grave problems with the expansive reconstruction of Chevron. Well, you can say that's true. So much so that even the initial champion of the project came to express a change of heart. Not only does that, you'd be talking about Scalia, he later said, it wasn't a good idea. Not only does reading Chevron so badly stretch the terms of original decision, not only does it call on courts to depart from the terms of the APA and our long-standing and never overruled precedent, right? Never overruled precedents, so they still stand. It also turns out to pose a serious threat to some of the most fundamental commitments as judges of the courts. Well, no shit. The judges are going to determine the law, then why are we even there? In this country, we like to boast that a person who come to court are entitled to have independent judges, not politically motivated actors, resolve their rights and duties under law. Here, we promise individuals may appeal to a neutral magistrate to resolve their disputes about what the law is. Right? Does that mean the appeals court may appeal? Individuals may appeal to a neutral magistrate? Or are the neutral magistrates the federal court instead of the state court? Everyone, we say, is entitled to a judicial decision without respect to persons. Right? 28 United States Code. Well, there's a statute. There's a law that says everyone, we say, is entitled to judicial decision without respect to persons. And a fair trial and a fair tribunal. Right? Case law. Under a broad reading of Chevron, however, courts often fail to deliver on these promises. Rather, they provide individuals the best understanding of their rights and duties under law, rather than provide individuals with the best understanding of their rights and duties under law, a neutral magistrate can muster. We outsource our interpretive responsibilities. Rather than say what the law is, we tell those who come before us to go ask a bureaucrat. In the process, we introduce into the judicial proceedings a systematic bias towards one of the parties. Nor do we exhibit bias in favor of just any party. We place a finger on the scales of justice in favor of the most powerful litigants, the federal government, and against everyone else. In these ways, a maximalist account of Chevron risks turning Marbury on its head. And Marbury is all about judicial review, right? Review the law, review the facts, review. Overreading Chevron introduced still more incongruities into our law. Why often we insist that it is a basic requirement of due process that no man can be judged in his own case. No man can be a judge in his own case. As far back as 1789, the court recognized that it's against all reason to entrust a legislature with the power to make a man a judge in his own cause, and therefore it cannot be presumed that the people have done it. Right? That's first in line, or first in time, first in line. That's the precedence. The fucking executive branch cannot be the judge in its own case. Yet a broad reading of Chevron requires us to presume exactly that, so long as executive branch officials can identify a statutory ambiguity or silence, we must assume that the law permits them to judge the scope of their own powers and duties, at least so long as their decisions can be said to be reasonable. Right, what's the definition of reasonable? Then there are the ancient doctrines of lenity and contra pro fintimen, which is basically if there's an error, then it's the draftee's fault, right? The error falls on the draftee, not on the one that's been drafted for. From the founding, courts in this country have construed ambiguities in penal laws against the government and with lenity toward affected persons. Here we promise our courts favor liberty, not prosecutions, prison time, and penal fines. Is that true? Where's that happen at? Because, people are going to court. Veterans are going to court for crimes based on the indictment of a grand jury. And under the UCMJ, that's not allowed. They're supposed to be tried in a military court. So, this isn't necessarily true. But anyways, that's some upcoming case he talked about. So traditionally, too, our courts have long and often understood that, as between government and the individual, the benefit of the doubt about the meaning of an ambiguous law must be given to the individual, not to the authority, for the state makes the laws. Right? They wrote in the ambiguity. These are all things that I think that you could use, as your reasoning and whatever it is you're going to try to get the court to do. Just say, Judge, read this dissent, and you will agree with me that you, Judge, need to make a determination on the law. A rule requiring judicial deference to executive interpretations of statutory laws, especially laws that carry both civil and criminal penalties for their violations, as so many do, cannot be easily reconciled with either of these historic commitments. Well, we can go to the 6th article of the Constitution again. Right, where it says the Constitution and laws of the United States, which shall be made pursuant thereof, and all treaties made, which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. And anything in this Constitution or laws of any state to the contrary, notwithstanding. Well, that makes it pretty clear that, they have to follow the 6th article, and they have to follow the United States Code, and they have to follow the Code of Federal Regulations. They're the ones that say that's the positive law, so, it's the supreme law of the land. It was done under the Constitution. Right, so a rule requiring judicial deference to executive interpretation of statutory laws, such as 1 Stat 23, saying this is the oath that satisfies the 6th article of the Constitution, and all these people need to take it, and if they don't take it, well, then they can't exercise the power of their office. Let's start there. We don't need to have a court case then. Right? It's a malicious prosecution by somebody who's in criminal contempt of court because they didn't take the proper oath of office. Doesn't matter why they said they have you in court. What matters is they don't have the authority to have you there. A broad reconstruction of Chevron defies still and other norms. When reading statutes, we insist the courts pay careful attention to text, context, traditional tools of interpretation. We demand interpretations that comport with how a reasonable reader would have understood the law at the time of its adoption. Right? That's another case that's happening right now. I guess it isn't done yet. They don't have the numbers in here yet. But a rule requiring us to suppose that statutory silence and ambiguities are both always intentional and always created by Congress to favor the government over citizens fits none of this. A rule like this that is neither a traditional nor a reasonable way to read laws. It is a fiction through and through, and one that requires pretty hefty suspension of disbelief at that. Nor has the maximalist reading of Chevron even proven workable in practice. To this day, federal government, Chevron's biggest beneficiary, has yet to offer a coherent explanation for when a statute is sufficiently ambiguous to trigger deference. And this was the assistant to the Solicitor General speaking. I don't think I can give you an answer to that question, how much ambiguity is enough. Thanks to all this ambiguity about ambiguities, courts have pursued wildly different approaches. Okay, blah, 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 blah. How about this? Overreading Chevron has profound consequences for how our government operates as well. It encourages executive officials to write ever more ambitious rules on the strength of even thinner statutory terms, all in the hope that some later court will find their work to be at least marginally reasonable. Right? It was reasonable, so we have to go with what they said. No, that's not the way it's supposed to work. When one administration departs and the next administration arrives, a broad reading of Chevron frees new officials to undo the ambitious work of their predecessors and proceed in the opposite direction with equal zeal. So in the Code of Federal Regulations, they get to go change the rules, right? Every administration gets to write its own rules. Fucking crazy. In the process, we encourage executive agents not to aspire to fidelity to the statutes Congress has adopted, but to do what they might while they can. Consider the regulations before us. Some time ago, the VA promulgated a rule consistent with Congress's instructions, one providing the veteran's disability benefits may be resumed the day following his release from active duty, which is right, was the old system, 26 Fed Regulation 1559, later 38 CFR 3.645 or 654. In the years that followed, Congress did not amend its laws in any relevant way, yet agency officials proceeded to revise their rules anyway to place new burdens on veterans and make their own job easier. Expansive views of Chevron encourage and reward just such sorts of these self-serving gambits. Overreading Chevron holds still other consequences for the rule of law. When the law's meaning is never liquidated by the final independent judicial decision, when executive agents can at any time replace one reasonable interpretation with another, individuals can never be sure of their legal rights and duties. Instead, they are left to guess at what some executive official might reasonably decree the law to be today, tomorrow, next year, or after the next election. Every relevant actor may agree that the agency's latest pronouncement does not represent best interpretation of law, yet, all the same, each new interpretation carries the force of law. Kavanaugh said that, whatever 2151 means. Fair notice gives way to vast uncertainty. Nor does everyone suffer equally. Sophisticated entities may be able to find their way. They have their lawyers who can follow the latest editions of the Code of Regulations, compilation of executive branch rules that now clock in over 180,000 pages. Those powerful and wealthy can plan and predict future regulatory changes. More than that, they can lobby agencies for new rules that match their preferences. Today, administrative law does not confine itself to regulation of large, sophisticated entities. Our administrative state touches almost every aspect of daily life. And often it is ordinary individuals who are unexpectedly caught in the whipsaw of all the rule changes a broad reading Chevron invites. Right? Because they allow it to happen, people took advantage of it. Mr. Buffington's case illustrates the impact of disabled veterans. Those who left active service before VA changed its rules received all their promised benefits. Those who served later did not. Not because of any change in law, only because of change in the agency's view. Right? So he got screwed out of things that veterans before him got. But the law didn't change. Only the way that the VA looks at the law. Because they get to write their own regulations. So this had to be for a separate video, but I'm thinking, okay, well, in that case, if you're going to go to this VA court they have, don't bring up the law, bring up the regulations. And we'll look at some regulations in another video that maybe we can do that with. In fact, I may try another case in that court just to see what happens. You know, making it about the regulations instead of about the law. So many other individuals who interact with the federal government have found themselves facing similar fates, including retirees who depend on federal Social Security benefits, immigrants hoping to win lawful admission to the country, and those who seek federal health care benefits promised by law. Because in all cases, you're dealing with an administrative agency first. It's going to say, well, we determine what the law says. So it's been that way since I've been here. I've been here 25 years. This is the way we do it. That's what they tell you. It doesn't mean it's lawful. It's just the way that they've been doing it. With the passage of time, the problems with reading too much into Chevron have become widely appreciated. Even Justice Scalia reconsidered his earlier support for broad judicial deference to executive interpretations of the law. See Decker versus Northwest Environment. I had to go look at that. Calling on the court to overrule the related something deference doctrine bundle. Many of these members of this court have expressly questioned Chevron's maximalism. Excuse me. The federal government itself now often waives or forfeits arguments for Chevron deference before this court. And it does not even in cases that might have once seemed obvious candidates for the doctrine's application. Right? The court isn't even asking for these things. They're just being given it. Right? Because it's become the precedence. Right? Because the government did not seek Chevron deference, we declined to consider it. As a result of these developments, this court has not invoked broad reading of Chevron in many years. Okay, so again, way back when we started reading this, one of the courts said the reason they're doing this is because of the decision that the Supreme Court made in Chevron. And the court's saying that the court hasn't invoked a broad interpretation of Chevron in many, many years. Lower federal courts have also largely disavowed the project. One recent survey revealed a substantial majority of federal appellate judges disapprove the broad reading of Chevron and avoid applying it when they can. Well, that's the appeals court. What about the district court? We don't start at the appeals court. Extraordinary number of federal judges have written about the problems associated with reading Chevron broadly also, or broadly too. Other notable voices have spoken. Several state courts refuse to import broad understanding of Chevron. So they're not, what they're saying is, well, they're not necessarily inclined, or not, that they couldn't be inclined to look differently and say, well, instead of letting the administrative state determine the law, interpret the law, that they can do it. And I'm just saying, well, maybe we got to ask them, right? Motion. Apply to the court to apply the law. So 15 states have filed an amicable brief, so, people are looking at it. The same goes for other Americans who still find themselves caught in the Chevron's So where did this start here? Unsurprisingly, given all this, the aggressive reading of Chevron has more or less fallen into desuetude. The government rarely invokes it, and courts even more rarely rely on it. The Federal Circuit's decision at issue here is thus something of an outliner, and maybe that's the reason to deny the review in this case. Maybe Chevron's maximalism has died of its own weight and is already effectively buried. But even if all that's true, it offers very little comfort to Buffington and future veterans who will be forced to live with the VA's rule and the Federal Circuit's precedent. The same goes for other Americans who still find themselves caught in Chevron's law at the time. No measure of silence on this court's part, and no number of separate readings on my part or so many others will protect them. Right, you just talking about it ain't going to do a damn bit of good, Judge. You need to issue a criminal complaint or an arrest warrant. At this late hour, the whole project deserves a tombstone no one can miss. We should acknowledge forthrightly that Chevron did not undo and could not have undone the judicial duty to provide an independent judgment of the law's meaning in the cases that come before this nation's court. Someday I hope we might. I would say you could use that last sentence, that last sentence right there, as proof to a judge that the court said, that Chevron did not undo and could not undo judicial duty to provide an independent judgment of the law's meaning. And that's all we're asking them to do. So if that's the case, then, well, what does this law mean, Judge? Right, being enacted by the Senate and House of Representatives of the United States of America and Congress assembled, the oath or affirmation required by the 6th Article of the Constitution of the United States shall be administered in the following form, to wit, I state your name, do solemnly swear or affirm that I will support the Constitution of the United States. And who does it apply to, Judge? Right, so this is the law. So that'd be like what they call an adjudicative fact, or not an adjudicative fact, a legislative fact. Right, and an adjudicative fact would be this oath of office. So here's adjudicative fact, Judge. How does the law apply to this oath? Does this oath, the way it's written, satisfy the 6th Article of the Constitution? When the first law passed after ratification of the Constitution says what it says, whatever 1 Stat 23 says. Or 4 U.S.C. 101 if you're dealing with a state court. Judge, this says this, right? How does that apply to the prosecutor? Is the prosecutor a state officer? Right, that's an adjudicative fact. Right, is he a state officer bound by 4 U.S.C. 101? Yes or no? Because, if they are, then before he proceeds to execute the duties of his office, which means we can't be having this hearing right now if he didn't do this. Right, this is a malicious prosecution if he doesn't already have it. Take this oath. Well, how do you prove he has it? Well, this is in 102, where such oath may be administered by any person who, by the law of the state, is authorized to administer the oath of office, and the person so administering such oath shall cause a record or certificate thereof to be made in the same manner as provided by the law of the state he is directed to record or certify the oath of office. So make the prosecutor bring in his copy. He's the one who knows who he went before to have it done. Let him bring it in. Okay, well, that's what I wanted to do. And I got through it, and it's just about an hour, so that's long enough. But, yeah, this is, if you wanted to find it online, if you put in no.21- 972, right? This is going to pop up on YouTube for you, or not YouTube, but on the internet for you. And you can look at it yourself. I'm just saying, if you look at this and look at the things it says, you have a court case, this is like the proof that you need to give a judge that says, look, the Supreme Court says you have to make a judicial determination and put it in the court case, because now he can't say he doesn't know. Right now, they're like a blank slate. They don't know jack. They're just taking in facts. So give them this adjudicative fact that the Supreme Court said, judge, that you need to make the decision. Now make a decision on this, and give them something to make a decision on. Which is where, again, by the time I do this, or somebody does it, that I help do it, it may read completely different. But, right, we're going to motion the court to take judicial notice of adjudicative facts, apply the law, and issue the order. Let's just read it real quick. So the 6th article of the Constitution of the United States requires, and this is just straight out of the Constitution, copy and paste, right? And then an act to regulate the time and manner of administering certain oaths, right? And I'll show you where that came from, because you could do this yourself. I don't need to do it for you. If you go in here and you put in 1 stat 23, one of the choices you're going to get is this thing from Wiki Sources. Right? An act to regulate time, manner of administering certain oaths. I basically just copied and pasted sections of this, right? Copy that part, copy this part, put it in a format. The reason this is format with double spacing and indent, it is, as I remember, this is how the federal courts like it to be. They want you to double space your text and single space and indent your quotes. So, an act to regulate time, manner of administering certain oaths was the first law passed by the United States Congress after ratification of the Constitution of the United States. It was signed by George Washington on June 1st, 1789, and mandates that prior to exercising any power of office, all right, now this comes right out of the verbiage, that the oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the following form, to wit, I, A, B, do solemnly swear I will swear or affirm, support the Constitution of the United States. Right? This formal oath is also required by Section 101 of Title 4 of the United States Code. That'd be that 4 U.S.C. 101, which its now name is Oath of Members of Legislature and Officers, to be executed by every member of the state legislature and every executive judicial officer of the state. And 4 U.S.C. 102 defines the proof of execution. Finally, the 6th article of the Constitution of the United States makes this Constitution, laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything to the Constitution, in the constitutional laws of any state to this contrary, notwithstanding. So the questions of the court are, is it an adjudicative fact that the esquire, claiming to be the prosecuting attorney, now, I'm talking about this to be a criminal case, but whoever it is, if they call themselves the attorney for the plaintiff, or, whatever title they're using, and the document that you're, because I'm writing this mainly for us being the defendant, not being the prosecutor, right? So it's either the prosecuting attorney, the district attorney, the attorney for the plaintiff, whatever they call themselves, right? It's somewhere on their documents they're putting in their signature block. So whoever that is subject to the 6th article of the Constitution of the United States, right? Yes or no? 1 Stat 23, 4 U.S.C. 101, 102. And if so, can prove execution of the required oath, of the required form of oath. That's the question I want the court to answer. Right? The conclusion. Justice requires the court apply the law to the law's subjects, which is what we would find out if we could get him to agree. Well, the esquire is bound by the 6th article of the Constitution to take an oath to support the Constitution. That's the first thing. That would make him subject to the laws that we're talking about. Right? 1 Stat 23 or 4 U.S.C. 101, 102, depending on which one it was you wanted to use. Okay, so justice requires the court apply the law to the law's subjects, find the prosecuting attorney, district attorney, attorney for the plaintiff, whatever they're freaking, however they call themselves, find that office in criminal contempt of court, liable for a malicious prosecution, and order the acquittal of the defendant. All right, that's what you're trying to get done. Apply the law to this man. If the law says he broke the law, then he is in criminal contempt. This is a malicious prosecution, and I demand to be acquitted. Be a wonderful day. Okay, I'm going to stop there, and I hope you all have a great day. I'd say Happy Veterans Day, but it's really not a happy day. It's a somber day. But to all you veterans, right, I'm going to do a video now, soon, after I put together something to go to the VA court about some of the other things that the Code of Federal Regulations says. The one we just looked at kind of worked against the favor of the veteran. But I've seen ones in there that work to the favor of the veteran. They just don't want to admit it. So let's see how that goes. Okay. Have a good day. See you.